Hi everyone, welcome all of you to my series of videos on Indian Contract Act. For today, we will be covering free consent. The things that I'm going to cover is definition of free consent, coercion, undue influence, transactions with Pardhanashing women, undue influence and coercion, misrepresentation, fraud, does silence amount to fraud, and distinction between misrepresentation and fraud and mistake. So these are the things I'm going to cover in the present video. Now, what is free consent? The term consent implies meeting of minds, that is, the contracting parties understand the same thing in same sense. And as per the Indian Contract Act, the general rule is no consent, there is no contract. That is, in absence of consent, there is no contract. And in English law, it is consensus ad item, that is, meeting of minds of the parties to a contract. Consent is said to be free when it is not caused by coercion, undue influence, fraud, misrepresentation, and mistake. So, yeah, if there is coercion, the contract becomes voidable. That is, there is some force in the contract. Maybe the old man is forcibly made to sign the contract, or maybe the old man is forcibly made to transfer the property in the name of a villain, like most of the time it happens in the movies. So it is coercion. Undue influence, there is some undue influence by one party over the other, and the other party signs the contract when he or she is under the undue influence, like teacher and a student, father and son, the spiritual guru and the disciple. Fraud, when somebody has intentionally done fraud. Misrepresentation, misrepresentation is intentionally, it is not done intentionally. In fraud, the misrepresentation is done intentionally. And the last one is mistake. Now coming to coercion. Coercion is forcing or compelling, either physically or mentally, a person to enter into a contract. The consent is sent. The consent is said to be caused by coercion when it is obtained by force under a threat. Legal definition, I will not go into it. You can read it. Now, from the legal definition of coercion, we mean certain things like committing any act forbidden by IPC. Anything which is forbidden by IPC is coercion. Or threatening to commit any act that is forbidden by IPC. Unlawfully detaining any property or any person also, and threatening to detain any property or any person is coercion. So these are the four things which come into the legal definition. What are the constituents of coercion? Yeah, so we have already done it. Now the question arises is, does threat to file a suit against anybody constitutes coercion? The law says that a threat to file a suit is not a coercion. Like You have given money to somebody and the other person is not returning back to you. You may threaten him that you will file a suit. This is not coercion, of course, it is your right. But threat to file a suit on false charges is coercion. Like most of the time, it happens, or in movies and all, the girl says that she will file a suit on sexual harassment against the man, maybe on false charges. So, this is coercion, or the objective in this case may be to blackmail the person. So, this is also coercion. Now, coming to threat to commit suicide. Threat to commit suicide is also not a coercion. But when it is done to make the other party enter into a contract, then it becomes coercion. Now, coming to the question of effect of coercion and burden of proof. The If there is coercion in any contract, the contract becomes voidable at the option of the aggrieved party, that is the party who has suffered because of coercion. The aggrieved party may decide to avoid the contract. That is, the aggrieved party may rescind the contract. If he does this, he has to restore any benefit received under the contract to the other party. The burden of proof that consent was caused by coercion lies on the party who wants to rescind the contract. It means that the aggrieved party will have to prove that his consent was not free and therefore he is deciding to rescind the contract. Now, coming to undue influence. So, we have the legal definition of undue influence, where the legal relations are such that they are presumed to be, that is, one party is presumed to dominate the other party and take unfair advantage. The relationship between parties is such that one of them is in dominant position and the party in the dominant position uses that position to obtain unfair advantage over the weaker party. Now, as per the Indian Contract Act, a person is supposed to dominate the will of the other under following circumstances: when he holds a real or apparent authority over the other. So the authority may be either real or apparent, and the instances are like father and son, master and servant, police officer and the culprit. And the second situation is when he stands in a fiduciary relationship. Fiduciary relationships are of trust and confidence. And the examples are of doctor and patient, trustee and beneficiary, solicitor and a client, spiritual advisor, guru and his devotee, or the disciple, woman and her confidential managing agent, parent or guardian, and child. Most of this are self-explanatory, but we have in detail about woman and her confidential managing agent. For this part, yeah, the woman and her confidential managing agent, I would give the example of the movie of Gulabo Sitabo, where the old woman had her managing agent and the advisor, confidential managing agent and advisor, the doctor, who was coming in disguise as doctor. And he gives shock to Amitabh Bachchan by disappear. She gives it a shock to Amitabh Bachchan by disappearing or taking a sudden decision of marrying somebody else. Now, yeah, as I said, we will be doing it in detail. These women are Pardanashin women. Who are Pardanashin women? Pardanashin women are those who observe seclusion from men. They observe seclusion from the other persons or the other men. They are except their close family members and their managing agent. Law grants special protection to such women. Such women are considered to be ignorant. The law considers them that they are ignorant of the outside world and they need to be explained about the contract in detail. Now, according to the law, a woman who goes to the court and gives evidence, the woman who fixes the rent with the tenants and collects rents, who communicates when necessary arises in matters of business with the men, other members of his own family, is not regarded as Pardanashin woman, even though she is wearing burqa or observing seclusion, but when necessity arises, she observes seclusion, or when necessity arises, she communicates with the men. So, such women are not considered as Pardanashin women. A Pardanashin woman can avoid the contract unless the other party can prove that she had freely consented the contract and the other party can prove that the terms of the contract were fully explained to her. She understood the implications of the contract clearly. She had free and independent advice on the contract, and it was intelligent and voluntary act of her own based on her intelligence. So anybody entering into contract with Pardanashin women must be careful on these points, that in case they are required to prove these things, they must be able to prove it. Otherwise, in future, the woman can refuse to abide by the contract because the contract is voidable. Misrepresentation. Misrepresentation refers to a statement made by one party to the other, and this induces the other party to enter into a contract. But this statement is not true. But the party which has given misstatement doesn't have any uh, false intentions, doesn't have any intention to deceive the other party. That is, the person making misrepresentation has done it innocently. I hope it makes sense to all of you. Essentials of misrepresentation. So it must be made innocently, believing it to be true, without any intention to deceive the other party. There is no intention to deceive the other party. There is no intention to commit fraud. The representation or assertion should be of facts material to the agreement. A mere expression of opinion cannot be regarded as misstatement. Statement must be untrue and was made with an honest belief that it is true. The person to whom the misrepresentation was made must have relied on it and must have induced him to enter into the contract. And the last thing, a party cannot complain of misrepresentation if he had the means of discovering the truth by ordinary diligence. Here I have an example. Uh, Mr. A was selling his sugar factory to Mr. B. Now, Mr. A says that the annual turnover of the factory is 500 tons. Mr. B is examining the books of accounts, in which it is clear that the annual turnover never exceeded 300 tons. Now, Mr. B had the option of discovering the truth with ordinary diligence, since he is examining the books of account. Now, he cannot say that it was misrepresentation by Mr. A. Now, coming to the effects of misrepresentation, if a contract is induced by misrepresentation, the aggrieved party has two options: may rescind the contract or may continue with the contract. That is, the contract is voidable at the option of the aggrieved party. When the party rescinds the contract, when the aggrieved party avoids the contract, rescinds the contract, he doesn't have the right when he had the means of discovering the truth with ordinary diligence, which we have already discussed, where he is not in fact led by misrepresentation. His decision was not based on misrepresentation. He cannot avoid the contract. Like Mr. A brought the shares of the company on the faith of its prospectus, which stated that there is some Mr. Grieve who is the director of the company. Now, Mr. A says that Mr. Grieve is not a director of the company and he wants to avoid the contract. But Mr. A was not aware of who is Mr. Grieve. Then his decision is not based on what is given in the prospectus, and therefore he cannot avoid the contract. And the second condition is he may act upon the contract. The agreed party, if it deems fit, may choose to go by the contract. So he has the two options: either avoid the contract or may go by the contract. Now, when he is going by the contract, he may insist that he may be put in the same position in which he would have been if misrepresentation made had been true. Like one person was selling his uh, internet cafe, and he says that there are 20 computers, all are working. He was under the impression that all the computers are in working condition. Now, the buyer, when he buys and checks, only 18 were working and 2 were not working. So he can ask the seller to get 2 repaired. That is, he must be put in the same position in which he would have been if no misrepresentation had been made. Now, damages for misrepresentation. Misrepresentation does not entitle the aggrieved party to claim damages. But, however, in certain circumstances, the party can claim for the damages, like when a company has called for public subscription or had issued prospectus for IPO, and someone relying on the statements in the prospectus subscribe to shares and thereby suffers loss, the injured party can claim for the damages. When an agent commits a breach of warranty of authority, he exposes himself to pay for the damages to the injured party. When the relationship between the parties is that of a confidential nature and one party suffers loss due to misrepresentation made by the another party. Misrepresentation and the burden of proof. To avoid a contract on the ground of misrepresentation, the representee needs only to explain that misrepresentation was made and it was capable of inducing the contract. and then the burden passes to the representer. Now, coming to fraud,